Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Let's start our day with Judge Simpson.
Who's the attorney on that? Who?
Assistant Public Defender Alexis Dirks with and on behalf of Ms. Ramirez. Ms. Ramirez, can you please state your name for the record?
She's muted. Mr. Ramirez, can you state your name for the record, please?
Melina Ramirez.
All right. And what are we doing on this?
Your Honor, I believe you should have a plea form in the file.
All right. I do. Plea form indicates that the defendant will be pleading guilty to the charge of use of a controlled substance, a one-year offense upon their successful plea to that charge count. Well, this says count 2, but I don't think that's what you mean. I think you're intending that count 1 would be dismissed.
Yes.
I'll make the correction. All right, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor, and I would be making the request for immediate sentencing as well, Your Honor. I believe the people will be objecting to that, but that'll still be my request.
People would not be objecting.
They would be objecting, Your Honor.
Your Honor, that is correct. I believe that in this case, to have a specification report, Ms. Ramirez is currently inside of OC. In this case, she is of gloves, and so Your Honor, that deciding what the proper sentence would involve a recent investigation report. However, she is
With what end goal?
Your Honor, perhaps she needs some drug treatment. She's supposed to, my understanding is she's.
Okay, you might be right, but the problem is she's in the custody of MDOC. I could order whatever the heck I want.
My understanding is she's actually supposed to be getting released for parole. That may be incorrect, but her release date was supposed to be February, but she had this case, and so I think she's actually getting out.
And Your Honor, if I may, so that's my understanding was she was supposed to be released in February. She's been flocked by the parole board. However, this offense is back from October of 2023. And since then, Ms. Ramirez has gotten treatment in the prison, and she has been engaging in substance abuse classes since. So I believe for those reasons, she should get immediate sentencing.
Okay. Mr. Ramirez, can you raise your right hand? You solemnly swear or affirm that testimony you're about to give will be the whole truth and nothing but the truth, so help you God.
Yes, sir.
State your name for the record, please.
Melina Ramirez.
All right. Mr. Ramirez, it's the court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor. It's punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. Did she execute this or you on her behalf?
Your Honor, she did execute this. I was
All
able
right.
to go over with it in person.
Got it. Mr. Ramirez, you signed an advice of rights form, is that correct? Yeah. All the MDOC dropped. Okay. Now, that's good. They must be having some problem. I'm gonna have to pass them at her.
Understood, Your Honor.
Court does call the case, People versus Demetrius Job.
Jake Kenny, proceed, Your Honor.
Good morning, Your Honor. May it please this honorable court, David Burgess on behalf of Demetrius Job, who's approaching, Judge.
Can't get past Mr. Killowell.
It's a door, the wall of people back there, Your Honor.
Your name, sir?
Demetrius Job.
Thank you. You're requesting an adjournment.
2 weeks if possible, Judge. I just got retained and I need discovery. I spoke to Mr. Kennedy. I don't believe there's an objection.
No objection.
Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
Judge, could I address one aspect of bond real briefly? Your Honor, I spoke with Mr. Kennedy. My client is currently on a GPS tether. I understand the serious nature of the charges in this case, but he has no prior record. Judge, he's 51 years old. He is actually on house arrest, and but I'm asking the court to consider removing the tether provision. There is a no contact. That the incident allegedly occurred at the prior place of employment that my client's no longer allowed to go to. I believe that's where the complaining witness resides. So I don't know if the people take a position, Judge, but I'm asking the court to consider removal of the tether. If not, then a removal of the home confinement provision, Your Honor.
And I would defer to the court, Your Honor, as you think, so long as the no contact order is in place. Not able to get back to the residents of this case. So that's really all I'm concerned about.
Has the victim been spoken to about this?
No.
Are they, the alleged victim in this case is still in the same area,
Still at the same.
Facility.
facility?
That does, my understanding, have security at all times.
Yeah, if you have to be allowed in and out, Judge, it's a assisted living place.
At the 100 South Board?
That's correct, Your Honor.
Yes, Your Honor.
Where she works?
That's where she resides.
Resides, Judge.
I'll let you. Request for removal of tether, court going to grant that. All tethers then by default in the home confinement would be removed.
Thank you very much, Your Honor.
Bond will continue in all other aspects.
All right. Thank you, Judge. Appreciate it. Thank you, sir.
Court calls case People versus Stephen Bauer.
Ready, Your Honor.
Jake Kenny, proceed, Your Honor.
Good morning again, Your Honor. May it please this honorable court, David Burgess on behalf of Stephen Bauer.
Your name, sir?
Stephen Bauer.
Likewise, you're asking for an adjournment.
Yes, Your Honor. Same 2-week adjournment if that's okay with the court.
Probable cause conference September 11th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you.
Nice talking to you.
Court does call the case of the People versus Marcus Jones.
That's called the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Jones. Mr. Jones, could you please state your name for the court?
Marcus Moore Jones.
Your Honor, in this case, we're asking to please set for exam. Discovery is complete.
One thing, your date of birth, 5304.
Yes, sir.
Yes.
Yes, sir.
Any objection to the court amending the complaint to reflect that date of birth?
No, the people, Your Honor.
No, Your Honor.
Find it.
Sure.
I have it on these. It only goes on the information. Okay, I'll let you deal with this. Keep voting on this. All right, you indicated discovery is complete.
Yes, Your Honor.
And your
What date? I did. And it's amended as to you're adding counts to, as to the Raymond on count 2. Well, hold
It
on.
may be 4 or 5.
Actually added count 4 and, oh. I think the dash is supposed to be 4 through 6.
Yes, Your Honor.
Okay, so 4, 5, and 6.
I haven't received an information, Your Honor. Did that like just come in?
I don't know. I'm seeing it for the first time. It's assault with intent to, you may want to look this over because count 4, well, there's count 4 and then count 4 is assault with intent to rob, arm, a life offense. Count 5 is possession by a committed person, 5 years. And count 6 is possession of ammunition by a prohibited person, also 5 year. Was this sent to defense counsel?
I am not sure, Your Honor. I cannot tell from my.
Here's what I'm gonna do. Let me pass the matter and then let you, because I don't know what effect that will have on your decision. In this case, we'll provide a copy. You guys are gonna amend the information or complaints in this case. You got to provide defense counsel a copy.
Absolutely, Your Honor.
All right, so let me pass it. We'll get you a copy, Mr.
Thank you, Your Honor.
Court does call the case People versus Sean Charnley. The PD case, Ms. White.
Here's the name. Assistant Public Defender Sandra White on behalf of Sean Charnley.
All right, what are we doing?
Your Honor, we are going to waive the circuit court so that he can get a global resolution with his other cases. I need to get the
Sir,
paper.
is that correct?
It is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I do.
And you understand you'll not have that here and you'll proceed to circuit court for further resolution.
I do.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ms. White,
Yes.
as to the arraignment,
Oh, we stand mute.
defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for September 11, 2025, 1:30, Judge Slay.
Thank you, Your Honor. We'll have to,
Bond continued.
I don't see that paperwork. We'll have to get it to you.
Thank you, Your Honor.
Court does.
Good morning once again, everybody. Welcome to the Courtroom Files Live, where apparently I'm losing my voice a little bit. Thank you to Barbara and Lady Jax for both gifting memberships. Very kind of you. Let's go down to Texas. Say good morning to Judge Stevens.
Yourself on the wrong side of this. Move yourself on the wrong side of this.
Where's that?
We now call cause number 24 DCCR 764, the state of Texas versus Omar Jimenez. Is that you?
Yes, sir.
Present with your attorney, Mr. Rojas, and the state's attorney is here. Earlier, you pleaded guilty to the second-degree felony of illegal possession of child pornography with intent to promote child pornography. And a pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
Not from the state. No corrections or changes, Judge.
Oh, then it is made a part of the record for all purposes. Also, we've received some supplemental information. It looks like it's dated August 26th, 2025. And the parties had an opportunity to review that.
We have.
And there are several letters, character letters on behalf of the defendant, and also a letter from the pre-sentence officer, Jody Roach, dated August 26, 2025. And does everybody have a copy of that?
Yes, Your Honor.
I don't know that I have a letter from Ms. Roach on.
That's what you got. That's his.
Is that the supplement?
Yeah.
Okay, oh, I'm sorry.
All right, again, the sentence agreement, the agreement that was reached by the parties, whatever sentence shall not exceed a cap of 6 years. So we are looking at no less than 2 nor more than 6 years confinement in prison, deferred or unadjudicated probation. And also, I believe regular probation is as well an option in this case. So, State, you want to begin or defer?
I'll defer, Judge.
All right. Mr. Rojas,
Thank you, Judge.
you may proceed. Thank you.
I guess the first thing you need to look at, Judge, is that something from Ms. Roach that came in on the 26th. There's some pretty damning statements made by Mr. Jimenez in that statement, or in this supplement.
Yeah.
I would point out, first I'll address the statements about the incident with his brother. I had a chance to talk with him about that this morning and his mom. Omar tells me that those were just fantasies, nothing happened. His mom tells me that when the investigators came out to do the investigation, the brother was taken to the Garth house and taken to counseling, and nothing was found to have happened to the brother. So at least there, nothing. Omar didn't act on those urges. And as far as the other statements in there, Judge, I mean, that I'll point out that this happened when he was 15 years old. He's 18 now. We're looking about 3.5 years ago when all this happened. He's gone on to graduate from high school. He's not gotten in any other trouble since then. And I think, Judge, if there's a case that
I'm sorry, how long ago did you say this occurred?
he was 15 years old. I might have said 2015, but he was 15 years old when it happened. I think it happened in 2022.
23.
Something.
March 7th, 23, 2.5 years.
Okay.
Yeah. Which we can get them disposed quicker than that, but we're a work in progress.
As the court, and I know the court's read the support letters we've sent, and as the court knows, the one of the purposes of probation is to rehabilitate those that can be rehabilitated. I think, Judge, that if there's a case that screams for rehabilitation, this is that case. We could send Mr. Jimenez to prison for whatever amount of time, but the reality is he's probably not going to get the help that he can get on probation. And if we're trying to avoid further victimization in the future, the help that he needs and can get is best given, I believe, through probation.
What help do you suggest is necessary in light of an adult making a choice to promote the victimization of a child by using pornography of a child?
Well, I think that's the sex offender treatment program.
What's like what?
Well, there's counseling, there's therapy.
What are they going to tell him? That's wrong. He didn't know that. He has an impulse.
And
that is attractive toward illicit behavior, immoral behavior at the worst sort. How do you change the preference in your conscience of that way? Any thoughts?
Well, I've never been through a judge. I don't know what treatment's available, but I'm sure that the professionals that can deal with that. And if they can't deal with it, then, you know,
Somebody else gets victimized.
well, I think he gets a chance on probation, and if somebody else does get not victimized, judge, but if he messes up on anyway on probation, then the court.
Well, he's got to get caught.
Well,
And pornography, like using illicit use of pornography, is generally a secretive thing. It's not done openly generally. That's why most folks who partake in this behavior aren't caught. We know that, but the ones who are caught, it's always serious. We have 39 individual images of child pornography. That is a violation of the child every time that is viewed. Then 54 videos of child pornography and a writing about his brother. So what we have is over 90 images and videos and writings of promoting the harm to children. Each one of those is a separate harm to that child.
Absolutely.
And we don't know where that ends. We don't know where it was distributed. And it becomes something that gets into the general public and accessible by the general public. And there is no end to it. The people, many of these people, most, are violated their whole life because you just can't put the genie back in the bottle when child pornography gets distributed, as we all know. But the question is, what should be done with the defendant? And not only in answering and being answerable to this crime, this serious crime, but how can we prevent it from happening? Again, if we can. Go ahead.
Yeah, and I think prevention, if it can be prevented, is best suited through probation. If you read I know the court has read all the letters, and they speak to redeeming qualities and good character as far as the witnesses know of Mr. Jimenez.
Do any of those letters on his behalf express the fact that they know what happened? They are fully aware of what he is accused of?
I believe they're aware of the charges. I don't know. I don't think they're aware of what the most recent supplement was, Judge, but they're aware of the charges.
The charge?
Yes.
But have they, in all realistic fashion, they did not see these 39 images or review these 54 videos?
I don't
Well,
believe
that's the test of, that's going to be the test of what you think of somebody once you see that. I mean, until they can see that, they really don't know much about it. It's like me saying, do you see my hand? Do you see my hand? Do you? Do you see my, do you?
Yeah.
Or now do you see my hand? You don't see my hand until you see the whole hand. The people know about you is not complete from what your actions were. Go ahead.
So as overwhelming, what most of the people in the letter say, that he's not beyond redemption. And I would just echo that, especially from Father Bado, from Assumption, saying that he knows him well, and the counselors there know him well. And in his view, he's not beyond redemption. I mean, again, Judge, these are things that happened when he was 15 years old. Between then and now, he's not gotten into any trouble. He's not been on any electronic. His parents have kept him off electronic device, no phone, no computers. They're going to help him continue that, because that's going to be a condition of probation, I'm sure, if the court decided to grant him probation. And that's what we're asking to do, Judge. Give him one chance on probation and let him prove, get the help that hopefully probation can give him, let him prove not only to the court, but to his family, that he can follow those rules and control those urges that the court's concerned about.
Okay. So everybody agrees that the defendant was 16 years of age on the date, March 7th, as alleged in this indictment. I'm sorry, March 7th. Yeah, he was born January 2nd, 2007. So he would have been 16 by 2 months, right?
Sure.
Everybody agree?
It was, okay, Judge, I'm sorry. Yes.
So he was transferred to adult status.
Yes.
Anything else?
No, sir.
Go ahead.
Judge, I struggled with going as low as I did on the offer. Mr. Rojas repeatedly talked to me over and over, and due to the age of the defendant, I lowered it down to below what I normally would on child pornography cases. But the thing that gets me is the selling. I mean, not only just looking and being addicted to it, but selling it and not even for a problem, just selling it and spreading it around. And it just listening to all these comments that he's made and sexual fantasies that he's had, and he's even had fantasies about his own brother and all the selling that he's done. I really cannot justify saying, let's try to get him some help when this happened. I haven't heard anything that says he's gone on his own to try to get help, that all he's done is just had his mom and dad watch him on the internet. He's just waiting to see what the court makes him do. And that doesn't tell me that he's ready to be rehabilitated. It says that I'm waiting for someone to force me to get some treatment and to try to get some help. I worry that this young man, that if we leave him out and he's fooling everybody about wanting to get help, that his brother's still there in the same household, that his brother's going to be accessible to him. And those fantasies, he said, he even admitted to the police officer that if he hadn't got caught, they asked him, if you hadn't got caught when you did, would this behavior have eventually led to you touching a child? And he said, most likely. He was just that close. I cannot justify him walking out the door because of the selling, the amount of images that he was selling. I mean, one of them in the PSI was, I'm selling all these 255 these files for 25 cents. He's got all these different files. I forget how many there were that he was selling, but he's selling them for 25 cents, not even for a profit, just selling them, just to spread them around. And that's disgusting that not only was he looking at them, but that he was spreading them around for everybody else to spread around. And that's what causes this stuff to get out on the internet and stay there. So we would ask the court to give him the 6 years in prison at the cap. I almost, when I read this memo that came in, I almost asked the court to kick the plea, but I made that deal with Mr. Rojas and his client, and I'm going to stick with it.
All right. Did you want to say anything, sir?
I just want to start off by saying,
Speak loud enough so she can hear you. She's got to take down everything. Thank
I
you.
want to start off by saying how deeply sorry I am, and how my actions affected the people, the parties involved
How do you think they affected the parties involved?
by the emotional distraught that reading the actions that I have done.
Where did you acquire all these images?
On Twitter.
All of it?
Yes, sir.
So you went searching for this?
No, sir. It just came upon.
What were you doing in Twitter in the first place? Look over at me, not up there. Over at me. We're focused here. Don't be thinking of an answer. You know what the answer is.
Just be looking, anything, videos, funny videos.
And so you chose child pornography as your focus of interest. Yes or no?
No, sir.
Well, that's what happened here. How many other things from Twitter have you recorded and preserved?
Only child pornography. sir.
Only child pornography. Only child pornography. What does that say? That's what you prefer. You're keeping it like it's a prize. How does that help you or these poor people who have been victimized? These young people. Over 90 sets of images and videos. How young do we know what the youngest child is depicted? Anyone?
I can't remember, Judge. I've been in trial all week and
I know. We do know what you write about your brother. Which is disgusting. If you're going to treat your brother this way, your own brother, a child, a little child, what would you do then? Given the opportunity to harm people you don't know and misuse their privacy. Yep. Pornography victimizes especially children, not only when it's made, but when it is promoted, used, acquired. And we call it the genie is out of the bottle. You can't ever find where it goes when it gets into the internet or the social media. And those, every time it's viewed or possessed or exchanged, those victims are re-victimized their whole life. There's no way you can put it back in the bottle. Forever it's out there or misuse, like what you did. What is normally done with this kind of behavior, because children are harmed, is that the statutes are severe and the punishment rendered, whether it's a jury or the courts, are generally most severe. Like what you've done. The difference in this case is that you were 16 when this was happening. You weren't an adult age, which is the only saving grace. It shows that's the only reason why the state did not ask for 20 years in prison. Would have been reasonable under these circumstances. You were what have you done since all of this came to light that has addressed this problem from this indictment that you obviously have you pleaded guilty to it, but how have you tried to address this when we caught you? What have you done to help fix this? Anything at all?
Went to the Our Lady of Assumption Church to find help, specifically with Father Kevin. And Father Kevin said I could join a CIO group, which then led me to help other people in the community, such as doing service hours, setting their parties, selling food for the greater good.
How does that help you overcome your preference for child pornography? What does that do? It seems to put you into an environment where more children and young people could be abused, right? No, I'm talking about what are you doing in your mind? What are you doing about your preferences to steer away from child pornography? And we're talking about infants, some infants. What do you do? What are you doing? Going to a church function, what does that do for you? How does that help this? How does that undo the harm? How does that prevent you from doing more harm? Well, tell me. You got a plan. What is it? Just not to go to parties and social functions. What else? What are you doing to try to fix this? You don't have a plan, really, do
And Judge,
you? Might not be mature enough to know what of a plan, but you're old enough to get in trouble.
page 1 of the pre-sentence report, the next to last paragraph shows that some of the videos I had was from infant to approximately 8 years of age for some guesstimation.
And how horrendous is that? I mean, that's unspeakable. When you were asked by Sergeant Lyon, who was the investigator in this, well, it looks like one of the lead investigators, he stated that he doesn't think you will succeed on probation because, among other things, you admitted to selling the pornography for monetary purposes, as well as your own prurient interests. Who did you sell this stuff to? Who did you sell this to?
Random people on the internet.
Sir?
Random people on the internet.
How?
My,
So you made money out of this.
yes, sir.
When he asked you if viewing child pornography was sexually gratifying to you, he says you shook your head yes. I'm sure he meant you nodded yes. But is that true?
No,
You made an affirmative response
Back then you told him.
when he asked you that? That's what he says here in this report. Is he lying?
No, sir.
Okay. Also, you have expressed further concern that you have admitted to having thoughts of harming your little brother. I don't need to go into details of what we're talking about here. Your own brother? Okay. By the way, he's 8.
He's 11 now, Judge, at the time.
He was 8 at the time of all. Okay. Anybody want to add anything else here?
Awesome.
No, Judge, just to reiterate that at the time of the offense, he was still a teenager and still developing his brain. And just ask the court to take that into consideration.
I took that into consideration with the offer I made.
How long will does he have any credit for any time in custody right now?
He was in juvenile for about 4 months. I think he was not in jail maybe a day or two. I think just doesn't have any jail credit, Judge.
Oh. Here's what the court is going to do. And we have two cases pending. He's pleaded to one. Is one going to be dismissed? All right. There's nothing further. The court is going to make the following findings that defendant who again was 16 years on at the time of the event alleged in the indictment, which is the same on both, has pleaded guilty to this second degree felony of illegal possession of child pornography with intent to promote by delivery and transference, as alleged in the indictment, of the visual depiction or depictions of children younger than 18 years of age who were pictured engaging in sexual conduct, namely actual deviant sexual intercourse. It's about as disgusting and horrifying for any parent to think that a child, their child, would be victimized such as that. But you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. And I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. The court is going to suspend that. You're placed on regular probation for 10 years. There will be terms and conditions of probation, which not only are relevant to this type of offense, but we're going to need to be creative on some strenuous conditions that target your preference toward child pornography and harm to children. You will, as a condition of probation, serve 180 days in the county jail. This does not go without confinement. This is most serious, deemed the most serious, but the statutes still allows probation in spite of the seriousness of the type of crime it is. The court finds because of your age, this is a fair and just method of handling this. But you have a conviction. You will go to jail. These are prices that anyone should pay for the harm to a child, or children in this case, a most serious harm. Yes.
There were several recommendations in the pre-sentence report. We'd ask that those be applied.
And the court is going to apply those to the conditions of probation, and a copy will be provided to the probation officer. And I had that thing here just then. And I've got all the letters and the probation cover, but Where's that, Mr. Laird?
It's in the pre-sentence report at the back. It may be already on the papers, but if you don't have probation papers though, do you?
No,
Okay, we'll have to draft them up.
stand by.
Or maybe they're attached there. There you go.
Yeah, on page 4, 5, and 6 of this pre-sentence report, which is made a part of the record for all purposes, by the way. The probation office has set forth 24 recommended conditions of a supervision plan that will be applied to the other probation terms that are normal and customary for people placed on probation for this type of offense, but this supplements it. Successfully completing an approved sex offender treatment program provided by a licensed sex offender treatment provider. No contact with children under 18 without authorization of the court. Submit to a sex offender assessment. Submit to polygraph examinations at any time at your cost in regards to whether you are failing to follow the terms and conditions of probation. Register with the sex offender tracking program. Submit a DNA sample to the Department of Public Safety. You shall also pay a fine each month under Article 42A 653, Subpart A of the Texas Code of Criminal Procedure, which is credited to the sexual assault program of the state of Texas. Avoid entering or approaching within 1,000 feet the premises or places where children gather, including schools, schoolyard, playgrounds, parks, amusement, arcades, daycare centers, youth facilities, and public swimming pools. Avoid supervising or participating in any program that includes participants of 17 years of age or younger, and that regularly provide athletic, civic, or cultural activities. Do not possess any printed, photographed, computer generated, or sexually recording images or recordings which record sexually stimulating or sexually oriented material, which is defined as obscene under Article 43.21 of the Texas Penal Code. Nor go on the premises of or patronize any places where such material or entertainment is available. Do not subscribe to or use any online computer services, bulletin board systems, social media network platforms, networking services, interactive messaging apps, or photo video sharing apps through means of any electronic devices, including but not limited to computers, cell phones, or gaming consoles, either at home, work, and unless approved in advance by the supervision officer and probation office and the court. You will allow the probation officer unannounced examination of all electronic devices that you have access to. You will apply in person to the Texas Department of Criminal Public Safety for an original or renewal driver's license, and thereafter renew the license annually in accordance with Article 42.016 of the Texas Code of Criminal Procedure. You shall pay a fine of $100 to the County Child Abuse Prevention Fund. You will be ordered to remain in your home from 6 p.m. through 6 a.m. on certain nights, which will be reviewed with you, where children are known to access, for example, like Halloween and other holidays. You must wear a probation issued identification bracelet during hurricane season so that when you may evacuate, you will be identified by your bracelet. perform 800 hours of community service. Do not accept any positions in employment where you will have access to anyone under the age of 18. And you will be at home curfew from 8 p.m. to 6 a.m. each night except for purposes of employment. You will be placed on the intensive supervision probation caseload until otherwise ordered. Complete a job search, submit to substance abuse assessment, abstain from all intoxicating substances, and submit to screening for drugs and alcohol. Do you understand these terms? And they will be reviewed with you. Failure to follow these can result in revocation of probation. These terms of probation, you can be revoked and sentenced up to 6 years in prison. You understand what you're facing and what you must do to fix all of this? Follow these requirements. So anything else?
Just clarification on the no contact with minors since the 11-year-old brother still is living in the home. So I can tell the parent, what should they make arrangements for one of them to be out of the home?
Number one, the parents need to be fully aware of what has been admitted to by the defendant in regards to his thoughts about his sibling.
His mother knows about that.
What does state say?
Judge, one of his fantasies is about his brother.
I know. What do you do? Well, what are you suggesting?
Well, they can make arrangements for, he's graduated high school of age now. He can move out. He can find somewhere else to go. I'm sure they've got relatives he can stay with or somewhere he can be. Until we get him some treatment, I don't know if we need to let him be.
How old is that child right now? How old is your brother?
11.
What are you asking?
Well, we've got
This is a first impression in 18 and a half years as a judge on this fact
I just
situation.
think
I've never really thought deeply about this.
And I have
It's realistic, but it is. It's always a possibility, but you never know until it happens. Yeah.
It's like, they can make arrangements for homeowner to find someplace else to live. They can have 6 months to do it. They can do that if that's the order of the court. I just wanted to know if that's.
I'm not going to order him not to have contact with the child. I'm going to order him not to have contact with the child when he's alone with the child.
Okay.
He can't be with the child unless the parents are around.
Can we make sure when he starts sex treatment, if the counselor recommends something different,
Yes.
we can readdress this?
Defer to what the experts will say on that and what they recommend. If they do that, you want a hearing on it, we'll address it.
Yes.
I just don't know if I've checked off all the boxes on this one. That's what I worry about. Is there something we're missing here to prevent future harm to others, sir? But let me say, you step 1 inch out of this box, we'll have you back here for a revocation hearing. Do you understand?
Yes.
All right. Anything else?
Okay.
I need signs. Is it here?
Oh, you need a minute?
Yeah, I can't. I feel like it's already in there.
I'm sure you got it.
I'd rather just like say.
Okay, friends. So in the pre-show today, I tried to discuss the fact that I felt like we were in a spiritual battle these days, good versus evil type of thing. And it was not the most artful discussion that I've ever had because my mind was in 1,000 places on the matter and my phone kept going off. So, not the best communication I ever gave. However, right here is the example of what I was trying to talk about, just this prevalence of evil right now. Now, this is a young guy, I guess, though he doesn't look that young. So if he is that young, his evil has already aged him. But I guarantee, well, hold on, he's back in front of the judge.
I don't know if they had it on the system back then. When we just updated.
I will have more to say, guys. I'm just waiting this out until he's done fully in front of Judge here. I thought he was, but then he popped back up. So let me make sure the Judge doesn't have more to say, and then I'll finish my thoughts. So hang tight.
Mr. Jimenez, you have pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your earlier plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of illegal possession of child pornography with intent to promote child pornography, a second-degree felony. And following this agreement, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That will be suspended, and you will be placed on regular probation for 10 years. There will be terms and conditions of probation, which will be reviewed with you, which include sex offender registration and terms and conditions of probation, which we have tried to produce here to not only protect others from your past behavior that you have capability of committing, but also to assist you in changing your behavior to conform to the laws, especially sex offender laws dealing with child pornography. Make sure you follow those conditions of probation. I've already told you what will happen if you fail. Do you understand what has occurred today, sir?
Yes, sir.
One other case is to be dismissed, correct?
Yes.
Thank you. And you will be ordered also as a condition of probation to serve 180 days in the county jail. How is that to be done?
But today, when we talked about this, you can go to the jail, you will fit it.
Do you work? Are you employed?
Yes.
We can do weekends.
I'm
Gonna
have two
last a long time.
in the 36 stuff.
Yes.
6 months, 30, but 30. That's right. It's easy. Something big like you stay. If you 6 months into 6 months in the church of the show, you do things so that you activities. Yeah, Judge, if you'll allow me to talk the other weekends.
Okay. That begins on or before 6 o'clock this Friday, and every Friday thereafter, you must report to the county jail on or before 6 o'clock PM, and they will release you for Monday morning. And you will do that each weekend until you have served 180 days consecutive weekend credit time, a total of 180 days. All right. Please see the probation officer. Thank you.
Thank you, Judge.
Thank you.
And it just keeps getting better, doesn't it? Now he's going to do this on weekends. Bailey, can I get a red carpet and a massage spa treatment too? Isn't that the truth? So back to my thoughts talking about evil. Given the age that this happened, somebody taught him this. Whether it was his parents or another family member or somebody close to him, I don't believe he stumbled across this. I believe there's a good possibility that he was that either he was sexualized right from the start or the ideas were placed in his head. I'm going to pause, Judge, here while I talk, and then we'll continue with him. Something happened there to help form him into this. That is evil. That turned him into evil. And Ashley, you commented how I don't like it when young people throw their lives away. I totally agree. But I'm not convinced that people who get into this stuff are reformable. So while he is young, this would be my exception to give him a shot. This is a person who needs to be put away. And instead, he's going to go on with his job, and he's going to serve weekends to get his 180 days done. And then be on a probation that he's not going to succeed at. He's going to be right back in this court at some point, and they're going to deal with it all over again because more people will be victimized. I guarantee it. That is what will happen. And, you know, we talk about evil. I like Judge Stevens. This ruling, in my mind, borders on evil. For everything that was done here, for him to get a slap on the wrist that he gets to serve on the weekends, and then a 10-year probation. I get he's got to register and all these things, but this dude needs to be put away, regardless of his age. And it's a shame that I guarantee you, I'll put money on it, something happened to him to make him this way. However, here we are, and it has to be dealt with, and this is not the way to deal with it. I know I normally don't preach like this on the live show. I save the stuff for the pre-show normally, but this just has me angered. Probably because in the pre-show today, we were trying to talk about good and evil and the spiritual battle that I feel is going on right now. This is just the perfect example of it. This young man is evil. Somebody taught him how to be that way, which in and of itself is evil. And a justice system did not take care of this properly, which unfortunately I would also regard as evil. This is a battle that we need to start understanding that we're in the middle of. Pick a side and fight. That's where I'm at. Let's go back to Judge, and hopefully this guy didn't do something similar.
5C on 696 and 697, the state of Texas versus Joshua Lyons. That's you?
Yes, sir.
Present with Mr. West, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about November 15th, 2024 in Jefferson County, Texas, you committed the third-degree felony of illegal possession of a controlled substance. How do you pronounce that? Silokin? P-S-I-L-O-C-I-N.
I would say that's how I pronounce it. C is softer, Judge. Silosin.
It is a third-degree felony, which carries with it no less than 2, no more than 10 years of confinement in prison and a fine up to $10,000. You understand what you're facing in this indictment, sir?
Yes, sir.
An agreement's been reached, but will be placed on deferred or unadjudicated probation for up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. And also a second pending case shall be dismissed as part of this agreement. Is that your understanding of the plan?
Sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will?
Yes, indeed.
Because you are guilty.
Yes, sir.
To show you what's marked here, States Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, whether the content's true and correct.
Yes, sir.
States Exhibit 1 tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, as you are mentally competent, and also understand fully what you're charged with here, as your attorney has read the indictment, or you've read it, and you are guilty of this crime served as alleged. Is all of that true and correct? So help you God. States Exhibit 1 made it part of the record for all purposes. Pre-sentence report, Wayne?
Yes, please.
I'm going to follow this agreement and find you pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt here, but I'm going to defer any finding of guilt. Place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense. There is no fine here. And the probation officer is preparing this order. I'm signing it. She will review this with you. They will make sure you follow these terms and conditions of probation. They're there to help you be the best person you can be. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 10 years. If you do well, it can be shortened. There we go. Please see the probation officer. Now, one other case is to be dismissed. Right.
I'm sorry, I'm sorry, we don't say that. Sorry, you got part. And then I'll talk to this one.
Let's change it up for a minute and go over to Judge Boyd. She has a young lady approaching with a smile on her face, so that's probably better news.
How are you doing?
I'm doing really good.
So is everything going okay?
Yes.
Everything going okay?
Yes, Judge, as a matter of fact, I checked in with her case manager, Ms. Tunisian. She said she's doing really well. My client also advised me that she got her high school diploma.
Congratulations.
Yeah, moving definitely in the right direction, Your Honor. Very proud of her progress. She's set to graduate in December. The only thing left she has is MRT, about 4 classes left, Judge.
Okay. All right. Well, I tell you what, I will come to your graduation.
Oh, thank you.
I'll be there too.
I know it's going to be great. So we're not going to say you're intending to, we're going to say she's going to graduate in December.
That's right.
All right. So then what we'll do is we'll recall this. Norma, can we recall this for November? Yes. But not interfere with the week of Thanksgiving, please.
That would work.
All right, so we're going to come back November 17th, and I know on November 17th, you're going to tell me, Judge, you said you'd come to my graduation, so it's happening. So we'll have you come back on November 17th just to make sure that you're on track, and I know you will be. All right, once you sign the reset form, you're excused.
Thank you.
All right, continue with the good work, okay?
Okay, thank you.
All right, thank you.
She's said that to other people, and I believe her that she will show up for a graduation if she's available, because she says it enough that if she didn't actually do it, somebody'd call her out on it. So good on her. Let's go back to Stevens, new contestant.
For 22-40055, the state of Texas versus Adam Cameron Dixon. That's you?
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does, and you may, Your Honor.
In summary, this indictment, we're only going on paragraph 1.
Right.
Alleges that on or about May 9th, 2022 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with the use of a motor vehicle. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached in your case where you would be pleading guilty. Sentenced. Is that a 5?
Yes,
Or
sir.
3? These are hard to find on. I'll be glad when it was all changed. Just like 5 years in prison. That would be suspended. You'd be placed on regular probation.
Whatever he decides.
And that could be
$500.
10 years in length. Recommendation is 5 years, but it's the court's discretion. You would be fined $500, and there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes, sir. Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
And because you are guilty. That was a question. Okay. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you're charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
We waive it. I ask for the waive.
I intend to follow this agreement. And if nothing further, I'm going to make the following findings: that you, Adam Cameron Dixon, are pleading guilty to this paragraph 1, a third-degree felony in this indictment, evading arrest or detention with the use of a motor vehicle. You are mentally competent to enter your guilty plea. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt, and you are pleading guilty voluntarily, knowingly, intelligently to this offense.
Yes, sir.
Correct. I now find you guilty beyond a reasonable doubt as you have entered your plea of guilty. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice, prison, for 5 years. But that will be suspended. You are placed on regular probation for 5 years. You must pay a fine of $500 and other terms and conditions of probation. The probation officer will review with you. Make sure you follow those.
Yes, sir.
If you fail, your probation could be revoked and you should be sentenced up to 5 years in prison. You don't want that. Anything else to add?
No, Your Honor.
We see the probation officer behind you. Thank you very much.
May he be excused?
Yes, thank you.
Thank you, Judge Stevenson.
Yes.
Nice day.
These are right now. Yeah, I'll put it right here. Want me to straight?
Let's go to Florida. We'll say good morning to Judge Glazer. It's 11 o'clock over there now, so creeping up on lunchtime.
Otis Brown, page 6. You okay with TAP, maybe?
He's got 5 HTO convictions.
You're old? Nothing recent? There's nothing like in this decade. Did you have Mr. Otis Brown, please?
Mr. Brown is present.
Good morning, Mr. Brown.
Good morning.
You were arrested for driving as a habitual traffic offender. I will appoint the public defender's office for you. You've been, it's 21 years. You have that don't have a valid license. You got to stop driving. Although there's nothing recent, I guess you didn't get caught. Can't you get your license straightened out? It's been 21 years. Go to the Drive Legal program. Do what you got to do. You haven't been in trouble in a long time. I'll give them the TAP program. Alternate bond, $2,500. No driving unless you have a valid license, sir. Good luck to you. Next case is Alfredo Miranda, page 6.
Don't felony bond. Spanish interpreter, please.
1 second. Good morning, sir. You were arrested for owning or possessing animals or breeding animals for fighting, and owning property for use of animal fighting.
Buenos días, señor. Lo han arrestado por estar en tenencia de o poseer animales o criar animales para peleas y estar en tenencia de una propiedad para peleas de animales.
And also you're out on felony bond. There's a hold for case F25-10014. It says AA. Must be a lot of defendants in that case.
Yeah.
Además, está libre bajo fianza por otro caso de delito mayor F25-100-148A.
Sir, can you afford to hire a private lawyer?
Señor, ¿usted tiene los medios para contratar a un abogado particular?
Tendría que buscar no creo.
He has regional.
I don't think so.
He has regional counsel on his other case, Judge.
Excuse me, do you own your home?
¿Usted es dueño de su propia casa?
Sí.
Yes.
You don't qualify for the public defender if you own real estate, and he shouldn't have the regional counsel in the other case if he owns his home.
No califica para un abogado de oficio si usted es dueño de bienes raíces, tampoco para el abogado regional en el otro caso.
Do you want me to reset this case in the afternoon so that you can hire a private lawyer?
¿Quiere que le aplace este caso hasta esta tarde para que tenga un abogado presente en la audiencia?
¿Cómo contactar a un abogado?
I don't know how to get in contact with an attorney.
Well, I'm not appointing one. You're going to have to use the phone or have a family call a lawyer, because if you own real estate in Miami-Dade County, you're not indigent and you don't qualify for the public defender's office.
Bueno, puede llamar por teléfono, puede pedir que algún pariente, algún miembro de su familia le consiga un abogado. Yo no le voy a nombrar un abogado de oficio, porque si usted es dueño de bienes raíces en el condado, no califica.
Yo no tengo ni la dirección no tengo ni el teléfono de nadie ni familiar que tenga de memoria, porque yo no he llamado a nadie porque no me sé el teléfono de nadie.
I don't know anyone's phone number by heart, no family members or anything.
Well, I'm not appointing a lawyer for you.
His daughter's here. I can.
Well,
give
there
her-
you go.
Mira, su hija
Wonderful.
está
Let me
aquí.
promote her.
My cookie.
Hello.
Oh, no.
Buenos días.
Hello, ma'am. Do you want to put on your video and unmute?
Señora, ¿puede por favor activar su video y micrófono?
I don't know. Is the daughter coming in? Does she want to be heard? Can you let her know he's going to have to hire a private lawyer? He doesn't qualify for the public defender. Maybe she can help him find a lawyer.
Sí, la hija está aquí, va a hablar ahora, ¿tiene algo que decirle a este tribunal? Bueno, su señoría quiere dejarle saber que su padre va a tener que contratar a un abogado particular porque no califica para el abogado de oficio, puede llamar a un
By the
abogado
way,
para que lo represente.
I just looked up his property on the property appraiser website. It's valued at over $500,000 for the market value.
Acabo de mirar su propiedad por la dirección y según el valor del mercado está tasada en más de $500,000.
I'm not sure why the public defender's office was appointed on his other case.
No estoy segura de por qué razón se nombró un
didn't do
abogado
that.
de oficio en su otro caso.
All right. Ma'am, did you want to say anything? Miss
Señora,
Ayan?
señora Ayon, ¿algo que quiera decir?
Miss Miranda.
Miss Miranda, excuse me, I apologize.
I think you promoted the wrong person.
I promoted
Señora
the wrong
Miranda,
person.
Ladies Miranda,
Can you help?
She provided her phone number in the chat, Judge, and I can give this to Mr. Miranda.
Thank you very much.
ella nos dio su número de teléfono, se lo voy a entregar al señor Miranda.
All right, all right, so do you want to waive a lawyer's presence or you want me to reset it in the afternoon for a lawyer? Because you're gonna have to
Señor-
see the division judge tomorrow anyway.
Señor, ¿quiere que proceda a la audiencia de hoy sin un abogado y le dé una fianza o quiere que le aplace su caso para esta tarde?
No, que me den una fianza ahora.
No, if you could give me a bond now.
Okay, so I'll set a bond. So what's going on here? It was a search warrant and they heard a lot of crowing of roosters in a fenced area of the home and got a search warrant.
So he feeds and trains them to sell.
Bueno, ¿qué fue lo que sucedió? Al parecer, obtuvieron una orden de cateo porque se escuchaba eh, los gallos, el canto de los gallos, y cuando registraron, hallaron que él los alimenta y los entrena para las peleas.
No, there's probable cause for the charges of setting the bond at $2,500, count one, $2,500, count two.
Hay motivo fundado para las acusaciones. La fianza será de $2,500 por el cargo número 1, $2,500 por el cargo número 2.
All right, sir, and you'll see Judge Hirsch tomorrow, and he can readdress your bond status because you're going to have a hold on your open case.
Permanece detenido por el caso que tiene abierto y va a estar ante el juez Hirsch mañana.
Have a nice day.
Que tenga buen día, es todo, señor.
All right, next we have Spencer Mano-Salva, page 7, bond out. Marlon Word.
He refused for you.
Ms. Coriano, he was present to reset it. I think he's on probation.
He has a probation hold for 2 cases. He has a baggie of MDMA. And he has more MDMA.
Mr. Word refused.
You want me to reset it, Ms. Corey?
No, Judge, we can waive his presence.
I'll appoint the public defender's office, waive his presence, bond is $2,500. Up next is Ephesus Morant, bond out. Darian Castillo, page 8. Morning, sir.
Spanish?
English
Spanish?
okay?
Spanish?
Thank
Español?
you. Good morning, sir. You were arrested for possession of a controlled substance within 1,000 feet of a school while armed.
Buenos días, señor. Lo han arrestado por tenencia de una sustancia regulada a menos de 1,000 pies de una escuela, mientras también estaba armado.
Armed possession with intent to sell cocaine.
Tenencia de cocaína mientras estaba armado con intención de venta.
Possession of cocaine.
Tenencia de cocaína.
Possession of a firearm, weapon, or ammunition by a convicted felon.
Tenencia de arma de fuego, arma blanca o munición por parte de un condenado delito mayor.
And possession of cannabis.
Y tenencia de cannabis.
Sir, can you afford to hire a private lawyer?
Señor, ¿usted tiene los medios para contratar a un abogado particular?
No.
No.
Do you own your home?
¿Usted es dueño de su propia casa?
No.
No.
All right, I will appoint the public defender's office for you.
Voy a nombrarle a la oficina del abogado de oficio para que lo represente.
I need a moment to review the arrest affidavit for probable cause.
Permítame un momento para revisar el informe de arresto y determinar si hay motivo fundado.
So no 1,000 feet because it's a traffic stop.
Okay.
I'm sorry, counsel, I couldn't hear what you said.
No 1,000 feet of a school since it's a traffic stop.
It's a traffic stop, so there's no enhancement for being within a school.
Se trata de cuando un oficial lo paró en el tránsito, así que no aplica la aparte de que está a 1,000 pies de la escuela.
So count 1, there's no probable cause, release outright.
Cargo número 1, no hay motivo fundado, será liberado.
I don't know, I don't see any independent sale activity.
No veo aquí que haya habido una venta independiente.
No, Judge.
So it's 5 plus, so it's 7 baggies, 8 grams. There's money, but I think he said he just bought.
Count 2, there's no probable cause for armed possession with intent to sell cocaine.
7 bolsitas, 8 gramos, pero me parece que dijo que no, que acababa de comprar.
Release outright.
Va a ser liberado por ese cargo. No hay motivo fundado.
Count 3, there is probable cause for armed possession of cocaine. He has a lot of priors, but not recent. He's a signal 200. Count 3,
Cargo
that
número 3, hay motivo fundado
is
para tenencia,
$2,500.
tenencia armada de cocaína, $2,500 de fianza.
Count 4, there's probable cause of possession of a firearm by a convicted felon, $7,500.
Cargo número 4, hay motivo fundado para un condenado delito mayor en tenencia de un arma de fuego, $7,500 de fianza.
Count 5, there's probable cause for possession of cannabis ROR.
Cargo número 5, hay motivo fundado para tenencia de cannabis, va a ser liberado bajo palabra por ese cargo.
Have a good day.
Buen día, señores todos.
You want any of these? Eric, you want any of these? Next, we have Taurus Norris, page 9. Good morning, sir. You were arrested for fleeing and eluding a police officer, possession of a weapon while committing an offense, and carrying a concealed firearm. I will appoint the public defender's office for you. There's like no priors. There's a gun. Why, it should have just stopped. There's probable cause for the charges. So what happened? He doesn't have a good license, so he didn't stop. He said he's not familiar with the area. He didn't think it's the real police. Okay, I guess you found out it was the real police. I'm setting a bond on count 1.
This is, again, Judge, an unmarked car stopping somebody over. I mean, you know, when these RID officers keep stopping people in unmarked cars, I think it gives people a lot of stress on whether or not they're actually a real officer.
Other officers came in to try and stop him, and he was taken into custody without incident. He had a gun in his waistband concealed. That's. Does he have any priors out of Broward?
No.
All right, I'll give him pretrial services, alternate bond. Count 1 is $2,500. Count 2 ROR, and count 3. I don't think there's a problem with the concealed weapon.
She's got a concealed license
says
permit.
that-
It's on the arrest form, the permit.
No, it said that it's currently in suspended status. So you can't
Oh.
carry concealed if you wouldn't otherwise qualify for. a
Count
permit.
3, there's probable cause.
But
That's
it doesn't say why he
$1,000.
wouldn't conceal he wouldn't.
Well, it's suspended.
It's suspended.
It doesn't
He's
say
got-
why, though, that if he
They
wouldn't.
don't have to. It's suspended. They don't give an explanation. It's suspended. He got pretrial. He got a break on that. You gotta stop when you see the police, sir. Have a nice day.
What was the bond on count 3, Judge?
$1,000. You can't carry it concealed when you're suspended. You can be facing additional charges, so don't do that. Have a nice day. Next, we have Jocelyn Martinez Perez, page 9.
Spanish interpreter, please.
Good morning, sir. You were arrested for 1 count of child abuse. I will appoint the public. Actually, can you afford to hire a lawyer, sir?
Buenos días, señor. Lo han acusado de un cargo de maltrato infantil. ¿Usted tiene los medios para contratar a un abogado particular?
No tengo.
No, I don't.
I will appoint the public defender's office for you.
Voy a nombrarle a un abogado de oficio para que lo represente.
So he's punching the 15-year-old child over and over again in the face because there was no cold water in the refrigerator.
Lo que dice el informe es que estaba golpeando con el puño al menor de 15 años una y otra vez en la cara porque no había agua fría en el refrigerador.
And he slammed him on the floor.
Además, lo tiró contra el piso.
So you are ordered to stay away. I'm not sure if this is his child or not.
Señor, se le va a ordenar mantenerse alejado. No estoy seguro si se trata de su hijo o no.
It's the same last name and they live in the same apartment, so I think it's.
Tienen el mismo apellido y viven en el mismo lugar. Parece que lo es.
So you were ordered to stay away from the victim whose initials are JM, the 15-year-old child?
Señor, se le ordena mantenerse alejado de la víctima, en este caso, el menor con las iniciales JM.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto o comunicación con esta víctima, ya sea de manera directa, indirecta, en persona, por escrito, por teléfono o mediante terceros.
No contact with the victim through social media or other electronic means.
No puede tener comunicación con la víctima por las redes sociales u otros medios electrónicos.
And you must stay at least 500 feet away from the victim, his home and school, and any place of employment at all times.
Debe permanecer al menos a 500 pies de la víctima, de su hogar, de su lugar de estudios o lugar de empleo en todo momento.
Renee, I need it back. Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se vea involucrado en ningún tipo de actividad ilícita y no use o esté en tenencia de drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No use, compre, esté en tenencia de o porte arma de fuego, armas blancas o municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar cualquier arma de fuego, munición o permiso para portar arma oculta a la estación de policía más cercana y traer recibo de que lo ha hecho al tribunal.
And you, in the event, also you may return to the victim's residence one time only within 48 hours of your release from jail.
También puede regresar a la residencia donde vive la víctima una sola vez hasta 48 horas después de su liberación.
You must be accompanied by a police officer
Pero tiene que ser en compañía de una escolta de policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
para que pueda buscar sus efectos personales, incluyendo ropa, medicamentos, documentación y herramientas de trabajo.
If you go to the victim's home without the police, or if you stay there, you will be arrested.
Si regresa a la residencia sin la compañía de la policía o permanece allí, será arrestado.
You understand? And in the event there's an open case in dependency court arising from the same set of facts and events as this case,
Y en el caso de que exista un caso en el Tribunal de Protección Judicial Infantil que surja de los mismos hechos y eventos que este caso,
then any and all orders entered in dependency court regarding your contact, visitation, and custody shall supersede or replace this court's order.
entonces cualquier orden judicial emitida por el juez del Tribunal de Protección Judicial Infantil en cuanto a custodia, visitas o contacto o comunicación tendrá efecto por encima de las órdenes de este tribunal.
Do you understand the stay away order, sir?
¿Entendió la orden de alejamiento, señor?
Okay, there is probable cause for the charge. I was setting his bond at $5,000.
Hay motivo fundado para la acusación. La fianza es de $5,000.
Have a nice day.
Buen día, señor. Es todo.
Next we have.
So I want to make sure I heard that correctly. Yeah, he beat the shit out of his kid because there wasn't cold water in the fridge. I that's what I heard, right? Is this like the modern day equivalent of Joan Crawford, Mommy Dearest, beating the crap out of her adopted daughter because her adopted daughter dared hang a dress on a wire hanger? People are evil. Spiritual battle, my friends. Good versus evil. Let's, we're going to have Sidebar tonight, and I have a feeling Sidebar is going to be very spirited. If you're not familiar with Sidebar, that is our discussion show that happens every Tuesday and Thursday evening right here on this channel, 8 p.m. Eastern, 5 p.m. Pacific. You should join us tonight because I think it's going to be spirited. Could be wrong, but I don't think I am. Let's go back to Judge Boyd.
All right, the court is calling 2025 CR 004887, State versus Juan Alberto Martinez. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Robert Featherston representing Mr. Martinez.
And you are Mr. Martinez? All right, your attorney has filed a motion for bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1. Let me see. Is it over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000. According to your motion, and you're asking for the bond to be reduced?
That's correct, Your Honor.
All right. Do you have any witnesses?
No witnesses other than Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Juan Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
My mother was just diagnosed with cancer a week ago. And Mr. President has been doing a lot for me, but my case has been turned over from DA to DA to DA. I'm innocent of this charge, but I'm pleading to the court in any way that you all can help me. I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone, but I am innocent of this charge, but I would plead no contest to the court. Whatever, if somehow I can get probation, whatever stipulation you can put, whatever.
All
I
right.
would
So
have-
this is not.
No, but I'm just
Time
stating
for
that I have,
equalization.
that's the problem with my mother. She got cancer. That's what he's stating, my mom.
Your Honor, if it pleases the court, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond, and then his bonding agency asked for a bond increase as a result of some issues associated with his bond. I think the state will probably go into more detail in that. But we're respectfully requesting that the court reconsider a PR bond for him. There is no violence involved in this particular case. And he would like to be able to provide some assistance to his mom. I'll pass it with.
All right, you may proceed.
I don't really have any questions in this particular case.
All right. So does he have any funds?
Judge, I'm appointed to his case. He is indigent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think that she's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything other than a bond.
All right. So what I'm going to do then, because you're saying there's no amount of bond he can make, he needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Your Honor, you were most kind, and I thank the court.
All right. So Norm, I want him evaluated for a PR bond. And then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
Not a problem, Judge. I'm here every day.
All right. Thank you.
Thank you.
Hey, Pops. Hey.
Let's head up to Michigan. We'll say good morning to Judge McNally. Haven't seen him yet today.
With rodent habitat and fair to maintain property, weeds and brush, it's excessive, it says. You have the right to a lawyer. If you want one, I'll give you one. Okay? We'll go give you a lawyer. You'll talk to the lawyer. Either way, you're coming back in front of me, okay?
Just have a seat in the hallway. Thank you.
Caldwell. Michael Wayne Caldwell. 25G82778. Name? You're charged with failure to obtain a rental inspection. I can arraign you or I can give you a lawyer. It's up to you.
I guess you can, I have everything completed now.
It is alleged that you did own a property at 14411 Stowfoot near South Gibraltar in Gibraltar, and that you failed to obtain a rental inspection. That is a misdemeanor punishable by up to $500 in fines, 90 days jail costs, or all of those. Those are just the maximums. Do you understand that? You just sign the advice of rights. Did you read it and understand it?
I did.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Okay.
If you plead guilty, we're not going to have a trial.
Oh, yeah, I'm okay. Yes, sir.
I'm just telling you that. You understand that?
Yes.
You still wish to waive your right to a lawyer.
Yes.
I'm going to enter a not guilty plea. I'll give you a $100 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. We're going to send you to the prosecutor, who's going to take you over to see the Gibraltar prosecutor. You'll talk to him or her. I don't know who's doing it today. And then you will come back. And if you don't resolve it, we'll schedule it again. Okay? So you can explain everything to them. Any questions?
No.
All right. Best of luck. Priority Waste LLC, 25T646160A and B. Good morning, council. I need your appearance, please.
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste.
Look at you. You look like a Hollywood movie star there with your sunglasses. So you're going to plead to overweight. They're going to dismiss the defective equipment. There's agreed upon fines and costs of $16.50. True?
Yes, that's correct, Your Honor.
To that charge of overweight, responsible or not responsible?
Responsible.
All right, plea is accepted. Defective equipment dismissed. Fines cost $16.50, paid by September 28th. Have a good day. Thank you.
Thank you. You do the same. Appreciate it.
Thanks. Okay. Ross. People against Devontae Dewan Ross, 25T645998A and B. And could I have Stacy Gee seated at the table here? My right, your left, sir, your name? Where you been?
Word. I saw it last day.
Why weren't you here August 14th?
I got the letter at a later time.
We gave you the notice when you were here July 31. You got to show up, son. You do this again, bring a lot of money with you because I'm going to set a high bond. You'll be sitting in jail. Do we understand one another? Yes?
Yes.
Is Trenton here today, Lisa?
Yeah. Do you need the prosecutor?
No, I don't. I need him to go pre-try the case. You waived your right to a lawyer previously. You still wish to do that? I can't hear you.
Yes.
Go talk to the prosecutor. Don't miss your court dates again. You understand?
Yes.
Either way, you're coming back in front of me. Okay? So you go see what you can work out with the city attorney. All right. That's his. Stacy Gee. Stacy Charmaine Gee, 238A, B, and C. And then I also have 25T645799. Your name? You had one from December. These are from December of 24. You haven't paid. How come? This is August. This is 8 months. Has she paid anything on these, Lisa? Where do you work, ma'am? Why not? Keep your voice up nice and loud. Why not? Keep your voice up, please, for me. How are you gonna pay these? I know, but you've had 8 months. I don't want to be rude about it, but you've had 8 months. You haven't done anything. Has she paid anything on any one of these?
paid $50 on March 7th and $60 on April 16th.
I mean, these tickets, like I said, they were issued back in December. How much do you have today? I can't hear you, man. Yeah, I know you're soft-spoken. It's okay. You gotta keep your voice up, nice and loud into that microphone.
I do have like 60.
Keep your voice up.
60, 70 guys.
60, 70? 60 and 70 or 60?
No, I think it's 70.
I'm gonna set you up on a pan. How are you reading? How are you supporting yourself?
I get this.
How much, let's set up a payment plan that you can stick with. I don't mind giving you extensions, but you can't ignore a court. You tell me how much you're gonna pay weekly, bi-weekly, monthly, whatever the case may be. But then the next step is gonna be, if you don't have the money, you have to come and talk to me, or you have to call the court and go on Zoom and I'll give you an extension, okay? You set up your own payment plan. You tell me what your payment plan can be. Nice and loud. What do you mean, maybe? When I set this, you gotta stick with it. And if you don't, you have to come with me. You have to come talk to me. Here's what I'll do. Lisa, we're gonna do 50, she's gonna pay 70 today on 238A. Balance at the rate of 50 per month. On this file, B and C, and then I'm gonna invite you to set up a payment plan on the other case too. Chief 645799. I'll give you a break on that one. I'll let you pay that, but you gotta come talk to me. Okay, if you don't have the money, do we understand one another? I'm easy to get along with if you don't ignore me. I don't like being ignored. Okay? All right, best of luck. Again, if you don't have the money, you're gonna call the court, we'll go on Zoom, or you're gonna come see me on or before that due date, right? And then I will give you all the extensions. If we have to do it for 3 years, I'll do that, but you gotta come and talk to me. Okay? All right. Tobias Elendell Moore, 25G3065990 A, B, and C. Good morning.
Good morning.
Your name? Lisa, okay, this was set for arraignment and pretrial, okay, Gibraltar. So you have the right to a lawyer. Do you want a lawyer?
Yes, sir.
Okay, we'll give you a lawyer. And then you're gonna go talk to the lawyer, and then you and the lawyer are going to come in together either way, no matter what happens, okay?
Yes, sir.
All right, we'll see you back here in a few minutes. Go out in the hallway, they'll bring the file out. Masuch. Jacob Kelly Masuch, 23T639985A, 23T640501. Your name?
Jacob. Is that your address?
Where you been? I feel like I need a recorder here. Where you been? Why haven't you been here? Like just one that I'm gonna use every two out of 3 cases. I thought, where you been? This is 2023 case.
Due to the date, I moved addresses, or I didn't have they sent it to my old address and I never received it.
Come on. You got a ticket handed to you, right?
Yes, sir.
Did you call the court and come in? No.
I didn't know nothing about it.
It didn't say, it doesn't say on here, appearance date on or before 10 days?
The date, I never received it. It happened after the incident happened, I never received it in the mail.
Who gave you the ticket? This is a drive while suspended, the police officer.
Oh, I thought you were talking, yeah. At that time, I didn't know I had it. But driving, I was suspended.
Did he hand you the ticket?
Yes, sir.
Did you call the court?
No, sir.
Okay. And then you got arrested and now you got a bond of $300, right?
Yes.
That's the only reason you're here, you got arrested. You have the right to a lawyer on this suspend charge. You also have an assault or assault and battery charge from 2023. Did you forget about that one too?
That was the one I didn't have knowledge about. I thought that's what we were talking about.
All right, I'm gonna give you a lawyer. We have 2 cases with Trent, suspend and assault or assault and battery. You go talk to the lawyer. Either way, you come back in front of me with the lawyer, okay? I'll be sitting here waiting. Thank you. Dejaya Wilson. 25B147786. No, Wilson. Dejaya Wilson. Mr. Gay said the defendant wasn't here. Somebody wrote that down.
That's from Gabe.
Not here. We don't have anybody on Zoom like that, right, Lisa?
On Zoom.
Defendant failed to appear for show cause. We're going to issue a bench warrant and cash 249, okay? People against Odea, Joshua Edward Odea, 25T644950.
Okay.
Let's actually change it up a little bit. Let's go back to Judge Stevens, new contestant.
Now you can hold this up. Right there where the officer is, the lady's gonna come right back.
Just stand in front of this. Stand in front of this. It's okay.
Keep changing my mind, so hopefully it doesn't last as long as it's keep going back and forth about whether it's very nine or nine. Why? Because I can't. Don't worry, I'm not. These are the ones back out. My parents, sure.
Thank you so much. CR 1573 is now called the State of Texas versus Quintavian Devon Johnson. That's you, present with your attorney, Mr. Burbank, and the state's attorney may or may not be here. What are you doing today? What is this?
We'd asked if it's an announcement.
Johnson.
And
We'd asked to request them to all be.
What if this? That's why I didn't know.
it's going to be set for trial.
Yeah, sure.
Do we have a pre-projection?
On this, and everybody get ready for trial.
Thank you.
I'll send you the other, it was a cat. You didn't say check all of it.
0.
Santos Navarez.
Yes, Your Honor.
Twenty-four CR 105 is now called your Santos Navarez, present with your attorney, Mr. Burbank, and the state's attorney. Earlier, you entered a plea to second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
I do, Judge. Can I address the court?
Yes, go ahead.
I don't know how the judge this court wants to handle this. I have some major concerns in reference to restitution. If you look in it, there were some factors, amounts that have been, presented through an attorney here. And one is that he's seeking for replacement value. I don't believe is correct when determining restitution in these types of cases. The second is that, we requested, that, there be some type of documentation, in reference to the money, and the item stolen, that whether or not they actually had ownership or that the money is actually, that amount was actually taken. So I'm requesting one of two things, Judge. Is we can place them on probation today and then set it for a restitution hearing.
That's what we'll do.
Thank you.
Anything else?
Not anymore.
Anything else other than what you've said
Yes, sir. That's it.
from the state?
No, Your Honor.
All right, if nothing further, I'm going to follow this agreement and find Mr. And it, by the way, the pre-sentence report is made a part of the record for all purposes of it. You have pleaded guilty voluntarily, knowingly, intelligently to this second-degree felony of burglary of a habitation. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, restitution will be ordered in an amount to be determined at a subsequent time. We will set this for a hearing as requested by the defense so that everybody has enough time to present the court information we need, and then the court will make its findings as to that condition of probation. Is there anything else?
No, Your Honor, and I'll get the coordinator to set a date that's convenient for everybody.
Thank you. There was no fine on this.
No, Your Honor.
No.
May he be excused, Judge, to go to the probation?
He's right here. Yeah, he's been talking. He needs a thumb. She needs a thumbprint.
So see her first? Yeah.
What happened?
Apparently issues resolution, so that we sent first. With two more separate.
Here we go.
Let's head back over to Judge Boyd for a few minutes.
Yes. Setting, we got a offer from the state that was a time limit. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right, so do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that.
No, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here, we're here, whatever evidence is presented, and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically, and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
A reason why I don't want to take what the state is offering me, because it's, I don't think prison is.
Here's the thing. Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants He wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed.
Okay, yes, so thanks. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No,
Judge.
no.
That would be today only offer since
All
would
right,
be
And
changing.
that's how I feel in track. Like,
all right.
I feel like I got an ultimatum. I feel like if I hire another lawyer, I have a better chance to, get a drug program, because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this. I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box and then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options.
Okay.
All right, thank you.
Okie dokie, let's go see what's going on with Simpson up in Michigan.
That being said, I need to have a discussion with him regarding options moving forward. So I would ask for an adjournment.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Dingman.
Court calls case People versus Anton Brooks.
Good morning, Your Honor. We please this honorable court. Brandon Bird on behalf of Anton Brooks. Mr. Brooks, can you please state your Anton Brooks?
Assistant Public Defender Natalie Pate, also on behalf of Mr. Brooks, in the case ending in 1261.
All right.
Your Honor, respectfully, we're just asking for a brief adjournment to get the body cam and go over it with my client.
You have green sheet.
And Your Honor, I am joining that request. The discovery in my case is complete, and I have reviewed that with Mr. Brooks, but we were just hoping to keep these two cases together.
Gotcha. So you have the discovery?
I don't have the body cam, Your Honor.
All right. Will the body cam be available in the next week? Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued, both matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Krista Riopel.
Master Veldis for the people. And Assistant Public Defender, Nancy Carriac, Your Honor, on behalf of Ms. Carissa Riopel. That's who you called, right, Judge?
Yeah.
Yes. But I do have a green sheet for the court. We are asking for an adjournment. This has been quite some time that we've been working on this case, but I think we're at the end. We did have mitigation completed. I have reviewed that with Ms. Riopel and I have forwarded to the people's attention. So they just need time to review for consideration.
All right. Ms. Riopel, can you state your name, please?
Carissa Riopel.
All right. Thank you. Probable cause conference will be adjourned September 11th, 2025, 9.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the People versus Rashad Keys.
The keys, Your Honor?
Yes.
Master Veldis for the people.
Good morning. May it please this honorable court, Kareem Johnson, appearing on behalf of Mr. Keys.
Keys, can you state your name, please?
Shaw Keys.
All right. Okay, what are we doing on this?
Your Honor, we have discovery. We're asking the court to set this matter for preliminary examination.
People have their witnesses available the 9th.
We will try for that. Thank you, Your Honor. I will alert the court there is a co-defendant who is up this afternoon with Mr. Bernstein, Mr. Durhal, it's in the 4 o'clock block. So obviously, people would like to keep the cases together if at all possible.
All right. And Mr. Johnson, have you been in contact with the co-defendants counsel on this?
No, Your Honor, I have not.
You have not.
Mr. Burnside's right here.
Will that work? Okay. All right. Just remind me because I'm not going to remember that by
I'll
4
do my
o'clock.
best.
All right. Preliminary examination in this matter in person will be set September 9th, 2025, 9 a.m. That's before. Oh, they're both before me. Bond will continue.
Thank you, Your Honor.
All right, thank you. Ready. Court recalls the case of the people versus Marcus Jones.
Again, Your Honor, Sam Bernstein with and on behalf of Mr. Jones. Mr. Jones, could you please state your name for the court again?
Marcus Jones.
Your Honor, thank you for the opportunity to pass and speak on it. We have discussed it. I don't know, do we need to do an arraignment right now?
Yes, we do.
Your Honor, we are in receipt of the amended complaint. Ask the court to please waive reading, and Mr. Jones stands mute.
All right. Defendant having waived formal reading of counts 4 through 6. Standing mute, the court will enter a not guilty plea.
And it's still his wish to move forward to examine, Your Honor.
So the charges don't affect your request for discovery, don't?
Oh, Your Honor, factually, everything remains the same. Thank you, though.
Preliminary exam. People have their witnesses available the 9th,
We'll drop that date, Your Honor. Thank you.
September 9th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you.
Well, one thing we can always count on is adjournments and bonds continuing. Sidebar tonight will be a half an hour earlier than normal, 7:30 p.m. Eastern, 4:30 Pacific, because Michael has a hard out at the top of the hour, and this will give us a little more buffer time just in case this is as spirited as we think it's going to be. Let's go back to Judge Boyd.
Counsel, you received all discovery. Did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated with a child under 15. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she does.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the United States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility There's a $2,000 fine. State recommends, the state recommends community supervision. They're taking in consideration 2025 CC 011952, and there's to be restitution to Victor Flores. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, ignition interlock for half the term, 2-year license suspension, parenting classes, AA meetings, and UAs. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State moves to admit what has been marked as State's Exhibit 1 in all attachment.
No objection, Your
All
Honor.
right, state, you may be excused.
Good.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I mean, this is her first criminal offense. I mean, obviously, situation she is at right now that the court has her attention. I believe she's going to be a very good probationer, and you're not going to hear from her again, Judge.
All right, so how often have you been drinking?
I haven't since then.
All right, so here's the thing, and I tell this to people all the time. When I was a defense attorney, I never had a client who said, my intention was to go out, get as intoxicated as I could, drive, hit someone. I've never had anybody say that. But the problem is when you go out drinking, you lose control of your normal faculties, both mental and physical, and then you go out and you hit somebody. And you had a child in the vehicle that could have easily been a dead child. That could have easily been a child that was severely injured, because usually, and I haven't done the statistics on this, my professor would be upset with me for saying this, but normally what I see, the person who drinks and drive, they usually end up walking away. The passengers end up being injured. The person they hit ends up being injured. You just have the soccer mom or the grandfather who's just enjoying their life, and somebody's drinking and they hit them. You're one of those people who cannot drink alcohol at all. And while you're on this probation, you're not allowed to drink alcohol at all.
Yes, ma'am.
So don't drink. You don't need to have alcohol to have a good time.
Yeah, and I've been sober since then. I haven't touched any beer, nothing, and I'm not trying to either, especially because of my kids and my granddaughter.
Okay. All right. This is what the court is going to do. The court is finding you guilty. Are you employed?
Yes, ma'am.
What do you do?
I work at O'Reilly's.
Auto parts.
Yeah, parts.
Okay. Well, you know, but now that song is going to be in my head forever. Thank you a lot.
But mine too, Judge.
That song's been in my head, especially because I did the parade for work.
So do you sell parts and give people
Yes.
advice?
I'm a dispatcher. I sell parts, I pull parts, I make sales, everything, basically.
All right. Court is going to sentence you 2 years in the state jail facility, suspended and probated for 4 years. There's a $2,000 fine. That will be probated. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be a TAP evaluation out of custody. Follow TAP recommendations, with the exception if they recommend inpatient treatment, we'll start with outpatient treatment. There's going to be 30 sober meetings in 30 days. 100 hours of community service restitution. I'm going to order the parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. Ignition interlock for half the term. A 2-year driver's license suspension. The victim impact panel live. DWI education course. And there's to be restitution, if any, to Victor Flores. Norma, I need a restitution hearing in 3 weeks, please. That's 3 weeks? Yes. No problem. I was like, are we already there? Yeah. All right, September 16th, the state is going to come in. State on this case, September 16th, that will be our restitution hearing. Taking consideration 2025 CC 011952. Probation, is there anything else? All right, is there anything else you need from the court to be successful?
Just anything that what I could do to stay out of trouble, which I still have been.
All right, just make sure you communicate with probation. That's a big start, okay? If there's anything you need, just let us know. Let probation officer know. If you feel as though they're not addressing it, you can come back to court. Do you understand?
Yes, sir.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and does she only have a warrant on this case? All right, so, and the court will recall the warrant. All right, thank you.
Thank you.
All right, let's continue the Texas ping pong, and we will go back to Judge Stevens.
Here's this. Done. 15-22728 is now called. The State of Texas versus Lisa Carmen. That is you? And you are here with Mr. Samuel, your attorney, and the state's attorney. There's a motion to revoke probation that has been filed as of August 18th, 10 days ago.
Yes, sir. She, if I may, Judge, she's here to basically turn herself in on that warrant. Mr. Samuel and I have been communicating about that. I believe ultimately there's going to be a resolution on the motion to revoke probation.
Resolution, one way or the other.
Yes, sir. One that may be worked out by the parties. Well, I'm in agreement to the court setting a bond on this matter. And based upon my conversation with the probation officer about how she's doing outside of the accusations in the motion to revoke probation, we would agree to a low bond amount.
I'm sorry?
We would agree to a low bond amount.
Okay. All right. Just for purposes of the record, to make sure you understand, Ms. Garman, this motion to revoke probation, among other things, states that you were placed on probation almost 9 years ago.
Yes. Yes, sir.
For the first degree felony of aggravated robbery, but you were placed on probation for 10 years.
Yes, sir.
It hadn't ended yet. And the motion, which was filed last week, alleges that you committed the offense of hindering apprehension of prosecution on or about December 16th of 2023. It's over a year and a half ago here in Jefferson County, Texas. And then you failed to pay court assessed fees as directed as of July of last month. As of last month, you were in arrears $2,932 for payments and fees, costs, etc. As part of your probation order. Let me ask you this, the restitution was owed in the amount of $400. Has that been paid?
Yes, sir. I had to pay it up front.
I thought, yeah, I normally order that.
Yes.
Is there anyone from the probation office here that can verify on Miss Carmen whether she had paid her part of the restitution?
So be on standby. I can call her real quick.
Thank you. Because I think it was to pay within 60 days of the day that you were placed on probation, and I hadn't heard anything.
Yes, sir. It's paid.
That was paid a long time ago.
Yes, sir. It has been.
Okay. I am looking at an administrative hearing that was presented to the court, but what is not here is a probable cause affidavit or some report of the incident. Does anybody have a copy of that so I can look at it? Have you seen this?
No, I haven't. But I know the basis of it.
Then you want a copy of it?
Yes, please.
Any objection?
No, Your Honor, I believe it's.
Thank you if you can make up
I
copies.
think we opened that up as part of discovery, but, I've done a few things. I may be mistaken on that.
Okay.
Anybody in this room's been doing a lot of stuff.
Agreed.
On which we printed money as much as we're
Legally,
working
right?
hard.
No,
If we printed money that hard, we'd all be the richest people on the planet.
I don't want to print money.
Yeah, I think that might be an offense.
Legal.
Judge.
Yeah,
Printing money legally.
I don't even think I want to take the chance.
You're just not going to sit down and just use your credit card for all of this, are you? All the expenses.
I think I've commented enough, Judge.
Yes.
All right, I'm looking at some motion to set bond that was filed here yesterday.
Yes, sir.
Thank you. Do you have this already?
Perhaps I should have that one back, Judge.
That was the one.
Yes, sir.
Yeah.
I was initially on her case.
On the original plea. Yes, you're right.
Yes.
Do you want to see the PSL? It's very fresh in memory.
Our restitution was paid for $300. She is delinquent $3,007 on everything, our restitution.
What is she's been on probation for how long now?
Almost 9 years.
How much is she paid toward her payments of fees in the 9 years? Other putting aside restitution of 400.
And she's presently employed, been employed for 2 years with, no,
Since I've been off.
She's actually been with the same place since inception, from what I can tell, Jeff.
right. She believes she's paid about 6,000 so far.
This is my copy of the PSI if you want to review that as well.
The original?
Yes, sir.
Oh. Have you read this? You haven't read this proper cause affidavit.
I read it a long time ago.
It's not good. I don't like it. I don't like what I'm reading here in this affidavit.
No,
Like I said, Judge, I believe we will resolve the underlying case.
Good. I don't like what I see here.
But
I watch.
But again, Judge, I took all that into account with the overall making the recommendation to the court that a low bond is appropriate, considering all the facts and circumstances. She's hired counsel. She's maintained employment through the entire time frame. The probation officer really sang her praises when I visited with her yesterday, absent what we've got to deal with later. And I believe that Mr. Samuel and I will resolve that.
Yes.
She paid 6,080. 6,080.
And we just asked the court to consider, there's only, huh?
Reminder about
Yes, she has only 4 members of the family still living. It's she, her sister, her grandmother, and her mother. She's a sole
What have y'all agreed on?
Huh?
I didn't agree on an amount, Judge.
What are
They
you
asked
asking?
me for a PR bond. I can't agree to a PR bond, but I something low.
What are you saying? He says 1,000.
I'm saying something low is appropriate, Judge.
Is that unobjectionable to the? Is that objected to by
She's $800.
I'm not going to object, Judge. Not based on
I'd
all
like
the
to-
information.
But look, I'd like her to focus on paying these other
And
costs.
I do know
and
her
what
funds are
happened here,
She will.
minus $1,000
Thank you.
in this motion to revoke adjudicated probation. The next event is
You will do.
so today. That again?
I can set it after we clear the floor. But if you guys.
Okay. For announcement, how much time? Is 4 weeks gonna be good?
Whatever he needs,
That's
Judge.
fine. It should be fine.
We should send that to me. Whatever you need,
You
Judge.
did.
What do you need, Judge?
What do you need?
All right, it's reset for 4 weeks.
Thank you.
Please get every sentence. Thank you. Is there anything else on that?
Only thing I asked, does she have to go into custody from here?
Yeah.
Or can she take care of that? Because
We're gonna do what's ever normal and customary. If the one thing we don't want to do is something uncustomary and then it blows up. Here, I think the thing needs just to trust everything, and everybody is not responsible. She needs to be put into custody immediately, then goes directly, checks in, posts the bond, and we will ensure that the jail knows that the bond is $1,000 for this motion to revoke probation. And then it should be just time for processing paperwork to get her out.
okay.
It's the best way to do it.
Yeah.
Okay, that's fine.
And it's normal and customary. We don't,
I understand.
we treat, we did something unique, then if something bad happened, then.
Yes, we don't want that.
No.
Thank you, Judge.
Okay, thank you. Anything
Okay.
else on this? Oh,
Thank you.
any other matters? We are,
Okay, friends, let's hop in the Wayback Machine just a little bit. We're going to go to Florida, Wade Mercer. This is about 2 hours ago when he did his first appearances.
DUI with serious bodily injury to another. Mr. Phillips, there is probable cause for the charge. Your criminal history is not bad at all. I don't know that I see anything really other than this, but Mr. Phillips, this is a serious felony charge you've been accused of. Mr. Phillips, I'm going to listen to the attorneys and see if there's additional information they want to make sure I'm aware of. Then I'm going to address your bond status. Mr. McDaniel, anything on behalf of Mr. Phillips?
Your Honor, just that has strong local ties, houses, property. He obviously works in the community. I think I don't recall, but I think the victims are just going to be his family members, I believe, from the accident. We'd ask the court to take that into consideration. With his employment and stuff, I mean, he's obviously, we'd say he's not going nowhere.
Mr. Mitchell, anything?
We just request that, we have a condition of no possession or consumption of alcohol for this while he's out on bond. And I don't know if he can have any conditions added to his driving privilege or status, but, if the court sees that necessary, we would.
Such as what?
Such as his license will probably be suspended from this. So maybe no driving without a valid license. I'm just speculating.
Okay, so Mr. Phillips, I'm not going to give you a conditional release because it's such a serious charge. DUI with serious bodily injury to another. I know it. I don't know the relationship, but I know that the person that allegedly had a collapsed lung has the same last name as you. I'm assuming that's a relative of some type. But I'm going to just set you the standard bond I would set for felony DUI. That's $5,000 cash or surety. Mr. Phillips, cash or surety means you can go through a bondsman. You do have a condition not to possess or consume any alcohol at all, and you've got a condition not to drive a motor vehicle unless you have a valid license. So, Mr. Phillips, if you're able to get a work permit, you certainly can drive. If you're not able to, if you don't have a license, you can't drive. And I know that you want to get that straightened out because of your employment. So, Mr. Phillips, you'll get these phone at the first appearance, sir. If you go through a bondsman, that's bond $5,000. Normally, that means $500 to a bondsman. If you decide to go through a bondsman and not post the whole amount. Mr. Phillips, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Phillips, we do need to give you a notice for your court date. So I'm going to ask the jail to give you a notice for your arraignment date. It looks like it will be today's the 28th. October 7th at 8:30 a.m. And they'll give you that notice before you leave the jail. You will not get a notice in the mail, Mr. Phillips. That notice they put in your hand for Judge Garcia's arraignment doc could be the only notice you get. Any questions, sir?
No, Your Honor.
All right, sir. Wish you the best.
Barbara robs from the rich and gives to the poor, and the gifted membership goes to Robin Hood. Thank you, Barbara.
One count of DUI with property damage, which is a misdemeanor or criminal traffic. Ms. Peterson, there is probable cause for the charge, ma'am. And Ms. Peterson, in your case, I believe there's been a tentative offer made because your criminal history is not bad. I think you had something about 20 years ago is the last thing I saw in your criminal history. I'm going to appoint the public defender's officer to represent you, ma'am. Please listen to Mr. McDaniel, your attorney.
Thank you, Your Honor. I've spoken with Ms. Peterson. At this point in time, she's going to plead of no contest to the charges listed. She was adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of public service work at DUI school, AA counseling as directed by probation, the minimum driver's license suspension, and she has signed a plea waiver form, waiver the right to jury trial and call witnesses.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Peterson, did you hear that agreement, ma'am?
Yes, sir.
Ms. Peterson, do you have any questions about that agreement?
No, sir.
And ma'am, is that the plea that you would like to enter?
Yes.
Ms. Peterson, I'm going to accept your plea of no contest to the charge of driving under the influence with property damage. Adjudicate you guilty of that offense, ma'am. Sentence you to 11 months and 29 days probation. Court costs and fines are imposed in the amount of $1,078 plus a special conditions you successfully complete substance abuse counseling and perform 50 hours of public service work and successfully complete DUI school. I do recommend the minimum driver's license suspension. Ms. Peterson, if you choose to do AA or NA, we're going to put a cap on it of 12 classes, ma'am. And lastly, there's the possibility of early termination. Ms. Peterson, if you do half the supervision and have no violations, it's possible that you may get off early. Ma'am, what's going to happen next is they're going to let you use the phone to call for transportation, to call friends or family. They're also going to let you get dressed in your regular clothes. Then they're going to bring you to the courthouse, Ms. Peterson, because that's where the probation office is at. The probation officer will meet with you. They'll answer any questions you have. They'll give you a copy of the probation rules in writing, and then you'll be free to leave. Ms. Peterson, if you do call friends or family, you can tell them that you can be picked up in 30 to 45 minutes at the courthouse, not at the jail, but at the courthouse. Any questions, ma'am?
No, sir.
All right, Ms. Peterson, we'll see you at the courthouse in a little while. Wish you the best. Yes, ma'am. All right. Yes. William Walden. Mr. Walden, good morning. Mr. Walden, you have a hold out of Liberty County. I took a look at it, and it looks like it's a violation of probation warrant signed by Judge Fleury, and it has no bond on it. So, Mr. Walden, you're going to be held for Liberty County. Mr. Walden, you may get down there today. Today's Thursday. It would not be unusual if it was Friday or Monday before you get down there, but when you get to Liberty County, you'll go to another first appearance in front of a local judge, and that local judge will address your bond. It very well may not change, but right now the paperwork we have says no bond. Any questions, sir?
No.
All right, sir. Wish you the best.
All right, man.
Jessica Fry. Ms. Fry, good morning. Ms. Fry, you're here for first appearance. You've been accused of one count of aggravated battery with a deadly weapon, one count of aggravated assault with a deadly weapon, and one count of misdemeanor battery. So, Ms. Fry, there is probable cause for the charges, ma'am, but I think you're entitled to a bond. I've taken a look at your criminal history, ma'am. Let me see if the attorneys have any additional information before I set you a bond, Ms. Fry. Mr. McDaniel, anything on behalf of Ms. Fry?
Your Honor, she's, lives here in the area. Works at Hardee's. This is a incident that happened with her son and her son's girlfriend, I guess. Just take those things into consideration.
Okay. Thank you, Mr. Mitchell.
Your Honor, the complaint made allegations that she had been drinking when this occurred, so we would request that she have no possession or consumption of alcohol.
Okay. So, Ms. Fry, the concerning part is the allegation. Now, this is an allegation that hasn't been proven. The allegation is you pointed a pistol at your son's chest and pulled the trigger, and he did not know the firearm was not loaded. That's what you're accused of. So you're going to get a pretty serious bond because of the accusation. The second allegation is you allegedly cut someone with a knife. Ms. Fry, your bond's going to be $15,000 on the deadly weapon, aggravated battery. That's a second-degree felony. $10,000 on the third-degree felony, ag assault with a deadly weapon because there was allegedly a firearm involved, and just $2,500 on the misdemeanor battery. Ms. Fry, when you add those together, your total bond is $27,500. But Ms. Fry, it's cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman. Ms. Fry, there's going to be a condition of no contact with either alleged victim, at least for now. If either one or both of them want to have contact, we'll cross that bridge if that happens. But for the time being, they're not here. I'm not going to assume they want contact. Ms. Fry, for the time being, there's no contact. What that means is if you do post bond, Ms. Fry, you've got to have somewhere else to go other than the residence they live at least on a temporary basis. Now, if they want contact, we'll consider that sometime in the next several days. But right now, no contact with the alleged victim. There's also an allegation that alcohol was involved, like Mr. Mitchell mentioned. So, Ms. Fry, there's also a condition imposed that you not possess or consume any alcoholic beverages while this case is pending. Ms. Fry, you will get to use the phone in just a few minutes now to try to post the bond. Do you have any questions?
No, sir.
All right, Ms. Fry, I wish you the best, ma'am.
What about my minor children at the house? Like,
So is Ms. Peterson still in the room out there?
Yes.
We'll come back to her in just a second then. We've got Ms. Lockwood. Ms. Amanda Lockwood, you're accused of one count of grand theft between $750 and $5,000. Ms. Lockwood, I think I'm the judge that issued the warrant in this case. There is probable cause. Ms. Lockwood, the criminal history I've got looks like no criminal history since 2004. Is that accurate,
Correct.
ma'am?
Yes, sir.
Nothing in over, that's good. That's great. It's really, it helps me. It probably helps you for today's purposes. Let me see if the attorneys have any additional information. Mr. McDaniel, I did note that the alleged amount stolen was barely over the threshold of grand theft. It was $798. I think the threshold is $750. So I'm aware of that. Mr. McDaniel, anything else I need to be aware of on behalf of Ms. Lockwood?
No, Your Honor.
Mr. Mitchell?
Nothing for the state, Your Honor.
Ms. Lockwood, given your, Mr. McDaniel, she prefer actually, I'm gonna offer a conditional release. So Ms. Lockwood, because your criminal history is nothing in 20 years and because of the allegations against you, I'm gonna let you pick between a bond and a conditional release, ma'am. If you want to post the bond, I would set a $500 cash bond unless one of the state or defense is opposed to a cash bond. No? Mr. McDaniel, if she chooses the bond, you okay with a cash bond?
Yes, Your Honor.
But Ms. Lockwood, I am going to offer you a conditional release based upon your history, ma'am. So if you want to post the bond, it's $500 cash. If you would like to accept the conditional release, I'm going to offer you that. You would have the standard conditions of every conditional release. Plus, Ms. Lockwood, you would have a condition to have no contact with the alleged victim. I think it's a former employer. So no contact with that business if you do accept the bond or the release. Either way, no contact. Ma'am, do you have any questions about your choice between bond and release?
Cash bond, Your Honor.
$500 cash bond, ma'am. As soon as you post that, you'll be released. You'll get to use the phone shortly, ma'am. Just remember the no contact condition. I'm going to ask the jail to give you a notice for your court date, Ms. Lockwood. And I don't know that I did that to Ms. Fry. I'm bad about forgetting that new process. So in both Ms. Lockwood and Ms. Fry, Sergeant, we need to give them both a notice for October the 9th.
7th.
October the 7th at 8:30 a.m. Ms. Lockwood, they'll give you that notice before you leave the jail, and that will be the only copy you get. The clerk won't mail you anything because they'll put it in your hand and you'll sign for it. Any questions, ma'am?
No, Your Honor.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. And back to Ms. Peterson. Was it Ms. Peterson that? So Ms. Peterson,
She's
going
actually-
back up. I'm
She's
sorry.
actually not, Peterson, she actually already went back to her cell, Your Honor. If you,
Okay.
you relay something to her, or try to get her.
Well, Mr. Goodson has got a text that says the jail may have to have a life management come out, so I didn't want to mislead her about the right to post bond. I wasn't aware of that when I saw her. So what is the status, Sarge, about with Ms. Peterson? Has she got life management evaluation due to Baker Act concerns?
Well, not necessarily think she's on suicide watch, so she'll have to be cleared by life management before she can post bond.
I need y'all to make her aware of that. She's got the bond I set, but let's let her know that the jail has certain precautionary steps they've got to take, and y'all are having life management evaluate her, and hope that's going to happen before lunch. Sergeant, is that normally how it works?
Yes, sir. We'll get her evaluated here this morning.
Okay. Mr. Mitchell?
She didn't get a bond. She accepted the offer.
Oh, yeah. She'll have to get cleared before she's released from jail either way.
Okay, I need to know about that. I had no idea. I saw the vest on. I thought it might be for a different reason.
Your Honor, would it be beneficial probably bring her back tomorrow or?
Well, I don't want her staying there overnight if she's cleared.
Yeah,
So
that's
if
true.
life management determines that she's a risk to herself or another person and she's Baker Act quality or criteria, they're not going to accept her, I don't think, with the probation. And I don't want to give her probation if she can't report. So if life management determines she's Baker Act, then what I need to do is just hold her until tomorrow. If life management determines that she is not a danger to herself or others, then we'll go ahead and bring her up after lunch to see Mr. Goodson at 1:30, hopefully. If life management can't see her today, then we got a big problem. I need someone from the jail to call me so we can figure that out. Okay, Sarge?
Yes, sir.
Anything else that you had today, Sarge?
No, sir. That's everybody here.
Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Thank you both. Mr. Mitchell from the state.
Nothing from the state, Your Honor.
Ms. Williams. All right, ladies and gentlemen, that concludes first appearances for today.
All right, folks, let's go back to Judge Boyd.
All right, and we are here for,
Compliance hearing, apparently he moved without permission.
could I see let me see if I have it. I think I may have it. Let me see. I have it. Y'all emailed it to me. Thank you. Right, so, sir, here's my question for you. Are you on probation? So why do you think that if you're on probation, you get to make your own decisions without contacting probation beforehand?
No, ma'am. I've been in contact with my probation officer. I let her know that I was gonna be losing my apartment, but I had permission to travel to Fredericksburg.
Oh, and did she say you could move to Fredericksburg?
No, ma'am, I was starting to stay there in the weekends and I lost my job.
No. See, you're not internalizing what I'm saying. Did probation give you permission to move to Fredericksburg?
Eventually, yes.
But no, before the move.
Well, I was staying there. I was spending the night there visiting, but I was not staying there. I still had
Did
a apartment
probation give you permission?
to travel. Yes, ma'am.
No, my question is, did they give you permission to move to Fredericksburg?
I wasn't-
That's either yes or no.
Not live there, no, but I was visiting.
All right, so again, you are on probation. Why do you think you can just do what you want to do? I'm sorry,
I don't think that, ma'am. I knew it.
but your actions are saying something different. You are not allowed to move to different places without probation's prior permission. When you're on probation, that is a contract. It does you no good to ask for forgiveness rather than permission. While you're on probation, you have to ask for permission. Because when you're coming with probation and you're asking for forgiveness, you know what that results in? That results in me getting notice that you're asking for forgiveness, which asking for forgiveness is a violation of your probation. So you need to ask for permission prior to making moves because you're under contract. You understand? Probation. Are there any other concerns? Has anybody received any type of documentation that he is actually now living in Fredericksburg? And then we have on this supplemental report that they made contact with you for 4 field visits. And they attempted to complete the field visits, but I'm assuming you were not there.
I mean, my work schedule had me away from home.
Did you tell them that?
Yes, ma'am. I had text messages where I was communicating with the visitation officer and I let him know the situation in my work schedule. And I also let my probation officer know.
Here's the thing. I don't know why they would put in their report they're attempting to make field visits if you made contact with them and said, I'm not going to be there.
They called me and they sent me text messages. And
Call you and said, where are you, right?
Well, they asked me if I was home and I said, no, that was at work.
So that's not, that again, that's, you're not understanding what permission is. Yeah.
Signed on August 25th, addressing transfer to reside.
This copy of
You cannot, I repeat, you cannot ask for forgiveness anymore. Do you understand? You're going to have to ask for permission. The next time you ask for forgiveness, what's going to end up happening is I'm going to receive notice. And in that notice, they're going to ask, should we do a compliance hearing? What should we do? And if it's the same thing where you're not following through and you're just living your life, and I know people just want to live their life, but when you're on probation, you just can't live your life like everyone else because you're on probation, you're under contract. Do you understand? So no more asking for forgiveness. You need to ask for permission. Now, is there anything else you need from the court?
No, not this time.
All right. So probation, you sent me this supplemental report, and they were asking for Sabbath is listed on here. So your conditions include intensive outpatient treatment. So have you been doing that?
My probation officer is waiting to get back to me, and I told her whenever we're available to start that I'm ready to start that. I've completed the 120 days. I started to look into parenting classes online and other resources online, so I should start taking
All
care
right,
of that.
so you need to start
And
intensive outpatient treatment ASAP. Anything else?
no, I was gonna finish by saying that I spoke with the probation officer. She said she was gonna get back to me as soon as she heard back from outpatient or whatever office or
They're here.
people were gonna, set me up for that so that I can start those classes on.
So you're gonna start it, okay?
Yes, ma'am.
Anything else, probation?
No.
All right, thank you.
Thank you very much. For your
You're welcome.
You have a great day, ma'am.
Thank you. You too. Thank you for dressing appropriately for court.
Yes, ma'am.
All right, let's go back to Judge Dad.
I have one, I brought one with me, I have two actually, one for the court and then one I can file.
Yeah, hand him up if you would, please. Nice to have you here.
Thank you, Judge.
Have I had the pleasure before?
I have never been here before, I'm out in Livingston County.
Okay.
And, took the ride down here, I actually like going to courts that I never visited before, at least once.
I got it. Does he have your name, sir?
Nicholas Warren.
Does he have a medical marijuana card now?
He does not, Your Honor, so, oh, you do? Okay, so Mr. Horn does have one. I have a letter, I understand the Marijuana Act. He does have a bona fide relationship with his doctor. I do have a letter from his doctor that recommends.
I'm not gonna have a problem with it if he has here's what I'm gonna do. So it says request for medical marijuana approval due to chronic pain in right knee caused by torn meniscus, and I do not want to be a drug addict. Psychiatrist and therapist recommended. Here's what I'm gonna do. Give me 1 second. Today's what, the 28th or 9th? 28th. All right. I'll just indicate defendant is not to be violated if he's positive for THC, so long as he possesses a valid medical marijuana card, okay?
Thank you, Judge.
So you're gonna have to show that to probation, sir. Okay, do you have it with you?
Yes.
All right. So you can go over there. Who's your probation officer?
Mr. Sino.
All right. So tell him I'm gonna send him over to show her the medical marijuana card, okay? What's Emily's number? 253? Listen, I've got a gentleman in front of me who has a valid medical marijuana card. I'm gonna allow him to use it so long as he possesses a valid medical marijuana card, or at least, yes. Do you need to see him for any reason? Okay, so that's exactly what I wondered. I'm gonna send him and his lawyer over to show you the card. Okay, he's got it. Thank you. Bye. You can go right over. I filled out the order. They'll give you a copy of the order, and you present that to Ms. Tessino, okay?
Thank you, Judge.
Thanks a lot. Mark William Techmeyer, 25G306589. Your name, sir?
Mark Techmeyer.
Okay, so you met with the department rep. You're going to plead to impeding traffic, correct?
Correct.
You got a clean record, good for you. To the charge impeding traffic, responsible or not responsible?
Responsible.
Okay, I'll accept the plea, dismiss the speeding, 150. You're all set. Cash you in the hall. You're right. Good luck.
Thank you.
You're welcome. Terrence Arnold Hall, 25T646123. Could I have Brandon Pantel seated at the table? That table up there, my right, your left. Ms. Terrence Hall, come on up to the podium.
You to the podium, you to the table.
Your name?
Wait.
Name?
Terrence Hall.
You're charged with driving on a suspended. You have the right to a lawyer. Would you like one?
Yes.
Okay, we'll give you an attorney. You can go out in the hallway. You'll speak to the lawyer. The lawyer will speak to the prosecutor. And then either way, you're coming back in front of me with your lawyer, okay? Good luck. Brandon Ross Pantel, file number 24B147651. Your name?
Brandon Ross Pantel.
You're charged with several violations here. I placed you on probation back on February 12th for 9 months.
Yeah.
And I have a charge that alleges you failed to attend your scheduled probation visit on August 11th of 25. That's count 1. Do you understand the charge?
Yeah.
Count 2 is failed to attend the Positive Strategies program with 8-week follow-up. Do you understand the charge?
Yes, sir.
Count 3, you failed to pay your fines and costs as ordered. Do you understand the charge?
Yeah.
If you plead guilty, or if you're found guilty, this would be 3 technical violations. You could get 15 days. That's if you're convicted on all. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights? I can't hear you.
Yes.
If you plead guilty, you'll be giving up all those rights. And there will not be a hearing or a trial of any kind. Do you understand that? You understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one at public expense. Would you like an attorney to represent you?
Yes, please.
All right, we're going to set you up with a lawyer. You go out in the hallway, and then either way, you're coming back in front of me with your lawyer after you speak to your lawyer, okay?
Sounds good. Thank you.
All right, thank you. Ross, Devontae DeJuan Ross, 25T645-998A and B. Okay, Mr. Ross, come on up here, tell me your name. So you met with the prosecutor, and you were going to plead guilty to the added count of no valid operator's license on person. You're also going to plead responsible to expired plate, as I understand it, and then they're going to dismiss the driving on a suspended, true?
Yes.
Is that what you want to do?
Yes.
No valid ops on person is 0 points. It is, the maximum penalties provided by law are up to $100 fines, 90 days jail costs, or all those. Those are just the maximums. Do you understand that?
Yes.
I can't hear you.
Yes, Your Honor.
Did you sign the advice of rights?
Yes.
Did you read it?
Yes.
Understand it?
Yes.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial. Do you understand that?
Yes, Your Honor.
Do you still wish to waive your right to a lawyer?
Yes.
To the charge, no valid operator's license on person, how do you plead?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
How do you plead to no valid operator's license on person?
Guilty.
Were you operating a motor vehicle in the city of Trenton, County of Wayne on Fort near Sibley at 9:13 in the morning on July the 8th of 25?
Yes.
Did you have a valid license with you on your person?
No.
Are you on probation or parole right now?
No.
Anybody force you to plead guilty?
No.
To the charge expired plate, how do you wish to plead? Responsible or not responsible?
Responsible.
I'll accept that plea, accept the no ops plea, dismiss the suspend. I find the plea has been made voluntarily and understandingly. You're still suspended, right?
Yes.
Why aren't you taking care of business here? Do you work?
Yes, a lot.
Where?
7-Up.
Where?
7-Up.
7-Up?
Yes.
What do you do there?
I make the orders for the trucks.
Okay, good. All right, you got to get your license back in order here. You're still suspended.
Is it possible to get on the plan for the plate?
For the plate? What do you mean? Yeah, I'll do that, but let's figure out how much I'm going to charge you first. Is there anything you'd like to tell me before I sentence you?
No.
100 fines, 70 costs, 75 victim's rights fee, $50 justice assessment, $295 or 60 days on the no ops, $135 on the expired plate. Your total here is $430. Do you have some of that to pay?
A little bit.
How much do you have?
Maybe like 75.
All right, you pay $75 now on the expired plate. That leaves you with a balance on that of $60. When can you pay that? Get paid weekly or not?
Weekly next week.
You pay the balance on that. Can you do that? And I'm asking you that. Can you pay the balance on that by September the 8th?
Yes.
And then on the other case, I'll just let you pay, can you pay 50 per week?
Yes.
50 per week beginning September 15th, okay?
Yes.
If you need more time, no problem, call the court, we'll go on Zoom. Or you can come in here on or before your due date, and I'll be glad to give you extensions. Just please don't ignore me, okay? I wish you well. Next time, show up in court though, will you please? All right, good luck. Is there anything else down there? Look at you guys with the teamwork.
Crazy day already.
Teamwork.
Yeah. We have a sign and record at Triangle.
All right.
All right, friends, it looks like he's wrapping up that segment of his docket, and it's probably a good place for us to call it a day. That's like 2 weird days in a row. I had fun, and I always enjoy hanging out with you guys, but I'll be the first to admit these have been a little bit taxing these last couple of days mentally. But we'll see what tomorrow brings. Tomorrow, you know, the Friday before a holiday, it's either going to be super busy or super dead, one or the other. So we'll see what it brings. But either way, we'll be here 10 a.m. Eastern, 7 a.m. Pacific, half an hour early for channel members. And be sure to join us for Sidebar tonight, a half an hour earlier than our normal time, 7:30 p.m. Eastern, 4:30 Pacific. And I have a feeling it's going to be incredibly spirited. And Lady Jack sneaks in at the last moment with a gifted membership. Thank you so much for that. I appreciate it. So look forward to seeing you all tonight. Again, 7:30 Eastern, 4:30 Pacific, and tomorrow morning as well at the normal time. In the meantime, go have yourself a great rest of your Thursday. Take care. God bless.